Hey everyone, it's your name from Law Rights. You know that feeling when you get totally ripped off and you're like, there's gotta be a law. Well, today we're talking about small claims court, your secret weapon for righting wrongs and getting your money back. We're talking about situations like your contractor did a shoddy job and refuses to fix it, your roommate skipped out on rent, leaving you with the bill. Small claims court is here for you. We're talking about cases up to $10,000. And the best part? You don't need a pricey lawyer to navigate the system. In this video, we're diving deep into the entire small claims process, from filing those initial papers to actually getting that sweet, sweet justice, which, let's be real, usually means getting your money back. So buckle up, grab a notebook, and let's do this. All right, before we unleash our inner legal eagles, let's make sure we're all on the same page. Small claims court, despite the name, can feel like a big, intimidating building full of confusing legal jargon. But trust me, it's not as scary as it sounds. Think of small claims court as the people's court. It's designed for everyday folks like you and me to resolve disputes without needing a law degree or spending a fortune on legal fees. We're talking about those annoying situations with neighbors, landlords, contractors, or that guy who backed into your car and promised to pay for the damages, but surprise, never did. Now, there are a few ground rules to keep in mind. First and foremost, the money. Each state has a limit on how much money you can sue for in small claims court, usually around $3,000 to $10,000. Pro tip, if your claim is for $10,001, you might be out of luck, so check your state's rules. Second, it needs to be a civil case, meaning it involves a disagreement between people or businesses, not something that would land someone in jail. Think breach of contract, unpaid debts, property damage, things like that. And here's a little secret. Small claims court is actually designed to be relatively quick and painless. The goal is to resolve these disputes efficiently and fairly, without all the complicated procedures and endless delays you see in TV courtroom dramas. It's justice at the speed of life, which, let's be real, is usually way faster than the speed of traditional court cases. Okay, so you've decided to take the plunge and navigate the waters of small claims court. First things first. Filing the claim. This is where the adventure begins. Kind of like starting a quest in a video game, only instead of slaying dragons, you're slaying bureaucratic monsters and fighting for your hard-earned cash. The first step is figuring out where to file. You can't just waltz into any random courthouse and expect them to hear your case. You need to file in the right jurisdiction, which usually means the county where the defendant lives or where the problem occurred. This is crucial. Get it wrong, and your case could be tossed out before you can say jurisdiction. Now, for the paperwork. Don't worry, it's not as daunting as it sounds. You'll need to fill out a complaint form, which is basically a fancy legal term for telling your side of the story. Think of it like writing a strongly worded letter, but with more legal jargon sprinkled in. In your complaint, you'll need to provide some basic information, like your name, the defendant's name, and a brief explanation of why you're suing them. Be clear, be concise, be factual. This is not the time for emotional outbursts or creative writing flourishes. Stick to the facts, Jack. Once you've poured your legal heart out into the complaint, you'll need to file it with the court and pay a filing fee. The fee varies depending on your state and the amount of money you're suing for, but it's usually not too exorbitant. Think of it as an investment in your legal well-being. Now comes the fun part, serving the defendant. This means officially notifying them that they're being sued and need to appear in court. You can't just send them a text message or slide into their DMs. There are specific rules for serving someone, and you need to make sure it's done correctly. Once the defendant has been served, they have a certain amount of time to respond to your complaint. All right, you filed your claim, which means you've officially entered the legal arena. Now comes the part where things get real, serving the defendant. This is where you officially put the other party on notice that you mean business. Serving someone might sound intimidating, like something out of a movie where a shadowy figure delivers a mysterious envelope. But in reality, it's more about following proper procedures to ensure the defendant is legally notified about the lawsuit. Think of it like this. You wouldn't want to be ambushed with a surprise court appearance, would you? Everyone deserves a heads up and a fair chance to respond to the allegations against them. That's what proper service is all about. So, how do you serve someone? Well, you have a few options. The most common method is personal service, which basically means handing them the court papers directly. You can't just ask your buddy to do it, though. You'll typically need an unrelated third party over 18 years old or hire a professional process server who specializes in this kind of thing. There are rules about where and how to serve someone. You can't just show up at their workplace and slap them with the papers in front of their boss, tempting as that might be. You also can't trick them into accepting the documents, like disguising them as a pizza delivery. Sneaky tactics are a no-go. If personal service proves impossible, maybe the defendant is dodging your calls, you can usually ask the court for permission to serve them by substituted service. This might involve mailing the documents to their last known address or leaving them with a responsible adult at their residence. Having proof of service, like a signed affidavit from the process server or a time-stamped photo of the defendant receiving the papers, is crucial. It shows the court that you've done your due diligence in notifying the other party, preventing any claims that they were left in the dark. Okay, you've filed your claim, served the defendant, and now the day has finally arrived. Your day in small claims court. Cue the dramatic music and the slightly intimidating courtroom setting. Don't worry, you've got this. First things first, let's address the elephant in the room. The possibility of the defendant not even showing up. You'd be surprised how often this happens in small claims court. People get busy, they get scared, or they simply underestimate the seriousness of the situation. If they fail to appear, you might just win by default. It's like winning a game without even having to play. But let's not get ahead of ourselves. Let's assume, for the sake of this epic legal tale, that the defendant show up ready to fight your claims. The courtroom can feel like a different universe with its own language and rules. But remember, at its core, it's still about resolving a dispute fairly and efficiently. The judge will typically start by asking both sides to present their cases. This is your moment to shine. Remember that well-crafted complaint you poured your heart and soul into? Now's the time to bring it to life. Present your case clearly and concisely, like you're telling a story but with more legal terms. Stick to the facts and avoid emotional pleas or dramatic pronouncements. Think of it this way. You're trying to convince a judge who knows nothing about your situation, so clarity is key. Be prepared to present any evidence you've gathered to support your claims. This could include photos, contracts, receipts, emails, or even text messages. Remember, a picture can be worth 1,000 words, especially in court. Organize your evidence neatly and be prepared to explain its relevance to your case. After you've presented your case, the defendant will have a chance to present theirs. Listen carefully to their side of the story, and take notes on any points you disagree with or want to rebut. This is not the time to interrupt or argue, even if you hear something that makes your blood boil. Stay calm, stay focused, and save your arguments for your rebuttal. Once both sides have presented their cases, the judge will likely ask you some questions to clarify any points of confusion. Answer truthfully and to the best of your ability. After considering all the evidence and arguments, the judge will issue a ruling, deciding in favor of one party or the other. Congratulations! The judge ruled in your favor. You stood your ground, presented your case like a pro, and emerged victorious from the battlefield of small claims court. You might feel a surge of relief, maybe even a little celebratory dance is in order. But hold on a minute before you break out the confetti and party poppers. Winning the case is a huge accomplishment, but it's only half the battle. Now comes the often overlooked, sometimes tricky part, actually collecting your hard-earned money. You'd think that after a judge orders someone to pay up, they'd cough up the cash without hesitation. Unfortunately, that's not always the case. In fact, studies have shown that a significant percentage of small claims court judgments are never collected. Talk about adding insult to injury. So how do you avoid becoming another statistic in the world of uncollected judgments? The key is to be proactive and persistent. Don't just sit back and wait for the money to magically appear in your bank account. Remember, the court won't chase down the debtor for you. It's up to you to be your own collection agency. First things first, communication is key. Once the judgment is final, reach out to the debtor and remind them of their obligation to pay. You can do this in writing, sending a certified letter with a return receipt requested, or through a more direct method, like a phone call. Keep your tone professional and courteous, but firm in your request for payment. If the debtor is uncooperative or ignores your attempts to collect, you have several legal options at your disposal. You can file a writ of execution, which allows you to seize the debtor's assets, like bank accounts, vehicles, or even real estate, to satisfy the judgment. So there you have it, your crash course in navigating the world of small claims court. It might seem daunting at first, but armed with the right knowledge and a healthy dose of determination, you can absolutely fight for what you're owed. Remember, the law is designed to protect everyone. not just those who can afford expensive lawyers. Small claims court is all about leveling the playing field, giving everyday people like you and me a voice and a chance to seek justice. It's about taking control of a situation, standing up for your rights, and refusing to be taken advantage of. It's about realizing that you have more power than you think. So, the next time you find yourself on the receiving end of a wrong that needs righting, remember this video. Remember the steps, remember the tips, and most importantly, remember that you've got this. Like this? Subscribe for more legal hacks. Comment your small claims questions below.